who for the past, since 1985, has been a water rights attorney. Many of you know him for the Navajo Nation and their Department of Justice. And we asked him if he might provide a few extemporaneous remarks to substitute for Susan's presentation. And this is a real story of the modern world. He pulls out his lanyard with his computer memory stick, and on it is a PowerPoint presentation as if he were prepared for today. So we are very fortunate to have, as a last-minute substitute, Stanley Pollack. So please help me welcome him.
I guess I thought I was fortuitous just bringing a coat and tie with me to the conference, and I had no idea I would need my flash drive. I've modified it a little bit to give you a little bit of background and some matters that you might not be familiar with in terms of Indian water rights. So what I'd like to talk about is the Navajo Nation more or less as a case study as far as the question of Federal Reserve rights on the Colorado River. I'd like to talk about how consistent with the speakers this morning about how the compact doesn't really envision a lot of the issues that are affecting Indian tribes, in particular Navajo Nation. So this is really going to be a case study in talking about the Colorado River Compact and the conflicts that arise. I think it was issue number 7 that Patty Limerick identified this morning. I always like to start off talking about the Navajo water rights within the context of the reservation itself. 40 to 50% of the households on the Navajo Reservation lack indoor potable water supplies. Those families have to haul water by truck. And it's with this backdrop that we talk about trying to develop water supplies on the Navajo Reservation for a variety of uses, but right now, in terms of the settlement efforts that I've been undertaking the last couple of years with the states, we've been looking at trying to get water supply projects so that people, to alleviate the problem of water hauling on the reservation. By way of background, let's just talk about the Winters case. It was mentioned this morning. I really hate these. Somebody can tell me how to stop the text from coming in. That's fine. The Winters case was decided in 1908, and Winters is the granddaddy of all Indian water rights cases for Indian tribes, and it's the case that stands for the proposition that tribes possess Winters rights. And more specifically, the Supreme Court in Winters identified the reserve water rights doctrine, saying that when lands were reserved for Indian nations, that those lands would be worthless without water rights, that the tribes never gave up the uses of water when they were confined onto much smaller land areas. I think in Daniel McCool's book, he has a book called Command of the Waters, and that's a phrase taken from the Winters decision. It talks about how prior to coming onto Indian reservations, the tribes had command of all the waters, all the resources at their disposal. Would they give up all those resources in order to live on small plots of land and not being able to eke out anything other than a poor standard of living? The Supreme Court said, we don't think so. And so Winters stands for the proposition that the federal government could reserve water from the unappropriated flows under state law, and that those waters would be reserved for the benefit of the tribes. So that was in 1908, and people had talked about the Winters doctrine, but nobody had really talked about what does it mean in terms of quantification of what a Winters right might look like. And it wasn't until the Arizona versus California decision in 1963 that the Supreme Court shed some light on this. But Arizona versus California emphasized the point that water is essential for the Indian people to maintain the lifestyle that they have on their reservations. The actual measure of that right, in the Arizona versus California case, they settled on the standard of the practicably irrigable acreage, that the only way to measure the right for the 5 tribes located below Hoover Dam was by the PIA test, practicably irrigable acreage. And what this means is the courts, and in this case the Supreme Court, looked at the available water supply. They looked at the resources on the reservation, and Special Master Rifkin said The resources on these reservations, there's an abundance of potentially arable lands. And just as the tribes were settled on the reservation for the purpose of creating a permanent homeland and for the purpose of returning to a more agrarian lifestyle, Judge Rifkin decided that without the use of water to achieve the agrarian lifestyle, which is mentioned in a lot of the treaties, the reservations would be useless. So the Supreme Court established the standard of practicably irrigable acreage as the measure of the water rights. However, when you look at Winters, Winters is really talking about trying to set aside water for creating permanent homelands for Indian people. And recently in Arizona, we litigated the issue about what is the appropriate test to measure reserve water rights. And in Arizona, the Supreme Court in Arizona, in what we call Gila River 5, said we decline to approve the use of PIA as the exclusive quantification measure for determining water rights on Indian lands. In other words, PIA is a factor. Practicably irrigable acreage can be a useful tool, but really what was at the heart of Winters was the concept of water necessary to create a permanent homeland. This decision has incredible ramifications for tribes like the Navajo Nation located on the Colorado River, particularly in Arizona where the Colorado River is at the bottom of the Grand Canyon, and you're up on Navajo lands several thousand feet above looking down at the Colorado River. And when you think about trying to use water for irrigation, use water to satisfy the practicably irrigable acreage test, lifting water several thousand feet for irrigation becomes quite problematic. And in point of fact, if you're talking about lifting water 2,000 feet for irrigation, unless the courts approve a standard that allows the tribes to be irrigating for, say, marijuana or opium, you're really going to have a difficult time satisfying the practicably irrigable acreage test. So this is a very important decision for Navajo. Okay. That's the backdrop, Winters, Arizona versus California. Let's talk about the Navajo rights in the context of the Colorado River Basin. You can see from the map here, we've got the upper Colorado River Basin, we've got the lower Colorado River Basin, and right smack dab in the middle, you can see the Navajo Nation. So you can see that most of the lands of the Navajo Nation lie within the Colorado River Basin, and Navajo is located somewhat strategically right in the crosshairs of the Colorado River and its disputes. You can see that Navajo lands are in 3 states of New Mexico, Arizona, Utah, and you can see that Navajo lands traverse both the upper basin and the lower basin. This makes my job complicated. It makes it also probably the best water law job there is. It's very fascinating to try to resolve these issues. This is a close-up of the basin maps. This is a map that I use to describe to my clients what I do for a living, and it points out that we've got general stream adjudications in most of the states. We have settlement discussions with the state of Utah. We have adjudication in the San Juan River Basin in New Mexico, Little Colorado River Basin in Arizona. We've recently filed a lawsuit, which if we have time we can talk about, with respect to the main stem of the Colorado River. We have lawsuits involving the general stream adjudications in the Rio Grande, and again in the Zuni River Basin in New Mexico. So it's a bundle of different issues. As I started my presentation, I talked about how one of the things that we're doing at Navajo is looking to develop drinking water supplies throughout the reservation. And this is a reservation map that shows we've sort of divided things into some strategic areas. But we'll talk a little bit about the Navajo Gallup Project, bringing water from Navajo Reservoir in the San Juan River down into the Eastern Agency of New Mexico. We'll also talk about some projects where we're trying to take water from Lake Powell and pump them up and make a trans-basin diversion from the upper basin into the lower Colorado River Basin. Let's talk about the Compact of 1922. I always like to say Colorado River Compact of 1922. 1922 is an important date because if you think about it, in 1922, Indian people were not even recognized as being citizens of the United States. Yet in the work that I do, and people say, well, you're trying to do this, that, and the other with respect to moving water around, people will say, well, the Colorado River Compact says you can't do that. That's the essence of this talk, why the compact doesn't really work in Indian country and certainly not for the Navajo Nation. Professor Adler talked this morning about the law of the river and how the law of the river, to many folks, has taken on biblical connotations. If you do this water law stuff, the law of the river is a Bible, and I like that analogy because when you look at the Bible, you can find virtually anything you want to support any point of view that you have. Okay, so here's what I like to look at. I like to look at Article 7 of the Compact. Nothing in this compact shall be construed as affecting the obligations of the United States of America to Indian tribes. It's never been really clear to me what that really means, but I think they're trying to say the tribal issues, we don't quite get it, we don't know what to do. But here's another interesting aspect of the compact. Look at Article 8. It says, present perfected rights to the beneficial use of waters of the Colorado River system shall be unimpaired by the compact. Present perfected rights. Present perfected rights. What the heck are present perfected rights? Present perfected rights under state laws, when you go out, you dig a ditch, you put water to use, you get a permit, bingo. In the context of tribal rights, present perfected rights in the Winters decision and is affirmed in Arizona versus California refer to the rights that vested at the time that the reservations were created. That's the essence of a Winters reserved right. The water did not need to be put to beneficial use to be recognized as a perfected water right. And that concept is embedded in Arizona versus California in the 1963 decision. Well, what does this mean? If the rights were perfected as of the time the reservations were created, the Navajo Nation's first reservation was created in 1868. That predates the Colorado River Compact of 1922 by many, many years. The lands that were set aside for the Navajo Nation in Arizona right along the Colorado River, set aside 1900. So whatever the water rights are for those lands, they are present perfected rights. Therefore, they cannot be impaired by the application of this compact by the very terms of the compact itself. So those are important concepts to keep in mind. With that, let's talk about, you saw the basins map and how we've got issues in all the basins. I'm going to talk about the issues on a basin-by-basin case study. Let's talk about the Arizona Upper Colorado River Basin. I like to start with this one because this is probably the most problematic area. On the map, you can see in the background sort of the outline sketch of the Navajo Nation located in the Four Corners. We are talking about the Upper Colorado River Basin in Arizona, which, except for some federal lands on the western side of the river, are located entirely, the Upper Colorado River Basin is located entirely on the Navajo Nation, plus the city of Page, which is sort of carved out in the Upper Basin. Article 3 of the Upper Basin Compact, this is the Upper Basin Compact of 1948 now. By the way, at that point in time, the tribes were voting members of the United States. They were recognized as being citizens, but just barely. In the Upper Basin Compact, the state of Arizona has been apportioned the consumptive use of 50,000 acre-feet of water per annum. Turns out this is the smallest allocation in the whole in the Upper Basin Compact regime. It's the smallest allocation that any state has. It's also the firmest water on the Colorado River, if you think about it, because what it says is this water comes off the top, and then the rest of the water in the Upper Basin is apportioned as amongst the other 4 Upper Basin states. So the state of Arizona is apportioned 50,000 acre-feet. Now here's where you get into the problem. Within that 50,000 acre-feet, the Navajo Generating Station is utilizing, Navajo Generating Station has a contract right to 34,100 acre-feet per year. They've never utilized more than about 30,000 acre-feet in any given year. But the Bureau of Reclamation is required to do an annual study of the consumptive uses in the basin, and according to the Bureau of Reclamation, they will say that current uses within the upper basin are at or near the limit of 50,000 acre-feet. And this creates a huge problem for Navajo, because if you look at the uses that the Navajo Nation makes of water in the upper basin, the uses tend to be very, very small. Stock ponds, some minor irrigation uses, some stock wells. Very little water is actually used. So there's not much water to be had in the upper basin. Now, the Navajo Nation in 1968 agreed that in exchange for essentially for the Navajo Generating Station to operate on Navajo land, to burn Navajo coal, that Navajo would make sure that its uses of water did not impair Arizona's ability to comply with its compact requirement of not exceeding 50,000 acre-feet of depletion a year. Those agreements expire in the year 2018. So what will happen in 2018 is probably anyone's guess. We know that the Page Power Plant, the Navajo Generating Station, seeks to operate beyond 2018, but the Navajo Nation also has various water projects that are planned for taking water out of the Colorado River for use for various community water supply systems. So this is the area that we have perhaps the greatest problem with the compact regime of saying the compacts put various limits in terms of what the states do. We don't think the tribes should be bound by that. Two other points. Obviously, I've mentioned that Navajo already agreed to be bound by those limitations in 1968. Those agreements expire. But one point of clarification. In 1963, the Arizona Supreme Court, when it was looking at the tribal water rights in the lower basin, the U.S. Supreme Court said that the apportionments for each of the tribes would come out of the state apportionments for the state that the tribe's use was located in. So, for example, the Colorado River Indian tribe, which is located in both Arizona and California, would have its California uses come out of California's apportionment, its Arizona uses come out of Arizona's apportionment. Fort Mojave, same thing, plus uses coming out of New Mexico. But what happens if the tribal uses don't fit within the compact apportionment? That's the problem we have here with Arizona in the upper Colorado River Basin, that the potential tribal uses far exceed the 50,000 acre-feet. And so how do we make that work? How we make that work is going to be an interesting question. I'm still trying to work on that. So we'll get back to that a little bit later. Let's talk about the Arizona lower Colorado River Basin. This is a shot of the Colorado River just leaving Lee's Ferry. Lee's Ferry is actually different than Lee Ferry for those of you trivia-ists. Lee's Ferry is where you put in for a river trip. Lee Ferry is a point that's located a mile below the confluence of the Priya River. That's the point where we have to have where the Colorado River is divided as between the upper basin and the lower basin. Now, in the lower basin, Arizona is apportioned 2.8 million acre-feet of consumptive uses by the Boulder Canyon Project Act, and the Arizona versus California decision of 1963 recognized that apportionment as being essentially the water right for Arizona. As you know, there's no compact in the lower basin, so essentially what Arizona versus California does is it uses the Boulder Canyon Project Act essentially as the compact for the lower basin in terms of apportionment. The Navajo water rights were not quantified in Arizona versus California. It turns out in 1957, Special Master Rifkin decided that he was only charged with looking at water rights above below Lake Mead, so he did not bother to look at the Navajo claims. More importantly, when the United States filed claims back in the late 50s, no claim was made to the main stem waters of the Colorado River, for the reason that the United States at that time was promoting the theory of practicably irrigable acreage. So if you can imagine trying to get water from the river, again, up above the rim for irrigation purposes, it doesn't work very well unless you're growing very, very high value crops, as I mentioned before. So what's difficult is if we wanted to take water out of the Colorado River in Arizona, you're looking at a diversion of taking water out of the Grand Canyon, and that in and of itself has a number of problems, not to mention there is a park there. But the park, again, postdates the creation of the Navajo Reservation. So whatever rights the Navajo Nation had to the Colorado River cannot be impaired by the creation of Grand Canyon National Park. Now, I'd like to talk a little bit about Jackass Canyon diversion. This is when we were looking at trying to find a water supply to solve a lot of the water controversies associated with Peabody slurrying pristine groundwater off the Navajo Reservation. They have a coal slurry where they slurry coal to the Mojave Generating Station in Laughlin, Nevada. We looked at trying to get water from the Colorado River, making a Colorado River diversion and basically bringing the water up to the Peabody mines for the slurry project. We were looking for alternate supplies of water. We wanted to show that this sort of thing that was feasible. And the site that we evaluated is the site here. It's called Jackass Canyon. This is the Colorado River flowing downstream. You can see Jackass Canyon to the right. This is Badger Canyon to the left. It's about river mile 30, I think. Badger Rapids is the first pretty major rapid on the Colorado River when you get to that. I was giving this a similar type of presentation, I think, to Governor Napolitano, and I kept talking about Jackass Canyon. Governor turns to me and she goes, "You know, you just like to say Jackass Canyon, don't you?" And so I said, "You know, Governor, when you work out in the Navajo Nation for as long as I have, they'll name a canyon after you." So. Okay, so looking down, this is Badger Rapid. You can see that it's a challenging spot. I include this picture in. My boss is here today. This is a plug to make sure that he understands that it's very important for me to keep taking Colorado River trips to be doing my field work for this study. Okay, so what we've looked at, instead of taking water out of the Colorado River at Jackass Canyon, is taking Colorado River water out of Lake Powell. Now, Lake Powell, as you know, is located in the upper basin, but we're talking about trying to use water in the lower basin of Arizona. We've looked at a number of different projects. The pipeline on with the red ink is the originally conceived Lake Powell pipeline, trying to bring water to the Peabody mine. The pipeline in blue is a pipeline that we're still currently evaluating called the Western Navajo Water Supply Project. The communities in Western Navajo have no water. There's no groundwater out there. There's no surface water. And so getting water from Lake Powell for drinking water supplies is absolutely critical. Okay, so that's Arizona. Let's talk about New Mexico. New Mexico compact issues. Article 3 of the Upper Basin Compact. Whoa, this is what happened. I was sort of in a rush putting this together. Somehow no apologies necessary. I've copied the Utah slide and put it in New Mexico, so we'll have to fix that. But the Upper Colorado River Basin Compact apportions to the state of New Mexico 11.25% of the water available to the Upper Basin. Let's get rid of that slide. Good. 11.25% of the water available to New Mexico in the Upper Basin comes out to about 669,000 acre-feet of depletion. And we've long maintained that Navajo water rights claims in the state of New Mexico could exceed the amount of water available to the state under its compact provisions. We recently negotiated a settlement with the state of New Mexico, the Navajo Nation New Mexico Water Rights Settlement, which quantifies the Navajo Nation's water rights in a manner that lets it fit squarely within the apportionment of the state of New Mexico. And we're talking about in excess of 600,000 acre-feet of diversion rights and a little bit more than 325,000 acre-feet of depletion rights. It all works out to about 56% of the water supply available in New Mexico. It's a significant compromise by the Navajo Nation, but in return for the trade of wet water for paper water, the Navajo Nation expects that the United States will help build the Navajo Gallup Water Supply Project, a massive piece of water development infrastructure in order to make this work. So that's an important point. When you're sitting down and talking to the states can't offer you any more water than they have. So we recognize that early in the game. We recognize the need to fit within the New Mexico apportionment. This is kind of a complicated map showing the Navajo-Gallup water supply project. I know the folks in the other room are going to have a hard time seeing this, but in the upper right-hand corner you'll see Navajo Reservoir, and that's located, of course, in the upper basin, and that dumps into the into the San Juan River. We have the project consists of two separate pipelines, one on the far eastern portion of the reservation, and one sort of that goes down Highway 491 between Shiprock and Gallup, New Mexico. So this is what's interesting about the project is we're taking water out of an upper basin diversion, and we're using water in the state of New Mexico in the upper basin, no problem there. Now you get some of the communities at Navajo lie in the Rio Grande Basin. Well, making a diversion from the Colorado River Basin to the Rio Grande is a piece of cake. The states do that all the time, and we don't really have a problem there. It turns out, though, if you want to take the water from the upper basin and deliver it into the lower Colorado River Basin, oh, no, that's a problem. Law of the river, can't do it, Colorado River Compact, yada, 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 yada. Basically, the Colorado River system is defined. The only provision in the compact that really applies here is the definition section. And by definition, it says the Colorado River Basin in each state is defined as that portion of the Colorado River that lies within the state and that portion of the state without the Colorado River. In other words, places like Santa Fe, New Mexico, Albuquerque, New Mexico, because they're in the Rio Grande, for purposes of the compact, they lie within the Colorado River Basin, even though they're in the in the Rio Grande Basin. But places like Gallup, New Mexico, which is in the Colorado River Basin, is not in the upper Colorado River Basin because it lies in the lower Colorado River Basin. So it's just a tautology of problems with the definition. So getting water from the upper basin into the lower basin in New Mexico has proven to be quite a challenge. The Upper Basin Compact Commission has passed a resolution authorizing this kind of diversion, and the idea would be that the water that's used in the lower basin in New Mexico, even though it's used in the lower basin, would count as part of the upper basin water supply. It would come out of New Mexico's upper basin apportionment. The same thing would apply here in Utah for diverting water from Lake Powell into St. George being in the lower Colorado River Basin. The Commission also said they approve the use of an accounting scheme where those waters would be charged against Utah's upper basin apportionment. We have legislation to authorize the project, to authorize the settlement. It should be introduced probably in the next couple of weeks. We know that the lower basin states are a bit squeamish about a lot of what we're doing here, about moving the water around and across the compact divide. We'll see what happens with the legislation. We've tried to tailor it in a way that we think will generate support among the 7 basin states. In addition, this project is also going to deliver water to Navajo lands in the lower basin of Arizona. So we're not just talking about an upper to lower basin transfer here. We're talking about an interstate transfer of water. And as far as the Arizona uses, the settlement legislation says that in order for Navajo to use the water in Arizona, Navajo has to have a settlement agreement with the state of Arizona authorizing the various use of water, et cetera, et cetera. In other words, Navajo is not permitted to take the water that it might obtain by way of settlement with the state of New Mexico and use it in the state of Arizona, because that's a compact violation. It doesn't matter that Navajo, in the view of the states, it doesn't matter that Navajo may predate the existence of the compact. Now, there's an interesting lesson here. I mean, we can talk philosophically, legally, theoretically about the compacts and what it means and whatnot, but the political reality is this. If you are an Indian country and you are trying to build a large piece of water development infrastructure, you have to go to Congress. The tribes do not have the resources to build a project of this magnitude. I mean, this project here is a little bit south of $1 billion in terms of cost. So if tribes are going to go to Congress, then the political influence that the states have, the 7 basin states, becomes really apparent. So you just cannot simply say in Indian country, we're going to turn our back and say, oh, the compacts don't apply. I found my quote in the Bible, and it says, it doesn't apply to the tribes. We have prior perfected rights. No, that's not going to work. In the political realm, these issues are really important, and in the political realm, these issues need to be resolved. And so that's what we've attempted to do. Another way of saying it is, if you're going to play the white man's game, if you're going to go to D.C. and ask for federal dollars, you're going to have to play by the white man's rules, and that's really the moral of the story on that. This is an interesting slide because this shows it's kind of a noisy slide, but you can see we have the Arizona boundary on one side, we have the New Mexico boundary on the other, but Navajo has water systems that crisscross the state, go back and forth, because when our tribal utility authority is out there developing water supply systems, they don't care where the state line is. And as one of our Navajo guys said in the negotiations with the state of New Mexico, these state lines are just completely irrelevant in Indian country. So we're moving water back and forth across state boundaries today, and the settlement we have with New Mexico would recognize those rights. Let's talk about Utah. This is the text that crept onto my New Mexico slide. Okay, Utah compact issues. Article 3 of the Upper Basin Compact apportions to the state of Utah 23%. That turns out to be about 1.37 million acre-feet of water a year. The good news is the Navajo claims do not bust the compact in Utah. So having discussions with the state of Utah is a much easier task than, say, having discussions with the state of Arizona for sure, or even the state of New Mexico. I have to give you a little anecdotal story here, just because now that I'm up here in Utah. We were actually meeting with state representatives yesterday to discuss the settlement discussions with Navajo. Just to put things into perspective, you saw how tight things were in Arizona and how difficult the compact issues are in Arizona. In Arizona, they're difficult people to work with. At the very first meeting we had with the state representatives in Utah, state engineer Jerry Olds sat down at the table and we talked about what we were doing here and what our goals were. And Jerry said, our objective here is to ensure that the Navajo Nation has the water it needs to prosper and to have a permanent homeland. And we all looked at each other and were thinking, we were used to negotiating with the state of Arizona. We looked at each other and go, what's going on here? The aliens have taken over the state engineer. And so I say that with a lot of affection because I know a lot of the folks from the state of Utah are here, and we are in the middle of settlement negotiations, and the negotiations are going rather well, and they've been very, very enjoyable. But let's talk about a compact issue that can create a potential problem here in Utah. If you look at Article 14 of the Upper Colorado River Basin Compact, it says the consumptive use of the San Juan River and its tributaries is hereby apportioned between the states of Colorado and New Mexico. What the heck does that mean? Well, really what that means is Colorado and New Mexico have the right to use the water of the San Juan River system to satisfy their state apportionments, and that Utah, according to our friends in New Mexico and Colorado, Utah would then be a junior water user whose rights would be subordinated to Colorado and New Mexico. So that's a potential issue that we are cognizant of. We think that as a practical matter, the compact won't be terribly limiting there. The good news is, and I know that a lot of people, particularly in Indian country, but a lot of people in the West like to diss the existence of the endangered fish in the river, but the good news is that because of the existence of endangered fish and because of the recovery program that we have, at Bluff, Utah, right here, that's one of the gauging stations within the critical reach for the endangered fish that we have. The flow recommendations for the San Juan River require that there be minimum flows at Bluff of 500 CFS. So the fish in many ways are an ally of the Navajo Nation to ensure that there's sufficient water that reaches the state of Utah, regardless of whether Utah is a senior or junior appropriator to get water. So we love the fish. This is what happens when you work backwards. I threw this in at the end. Again, in the upper Colorado River Basin, we also have some more religion here where it says nothing in this compact. Again, it's the same language as you have in the compact of 1922. And little aside, again, the Navajo lands in Utah predate the Upper Basin Compact of 1948. So since they predate it, the idea that somehow the states of Colorado and New Mexico can make some apportionment as between themselves, irrespective of Navajo rights, is anathema to the principle that I said that it shouldn't apply to the tribes. Okay, accommodating Navajo water rights. We have a number of projects. They cross state lines. We have a problem in the Upper Basin in Arizona of the 50,000 acre-foot limitation to Arizona. The lesson here is, I think, for us to make some headway to resolve all these things is going to require creative solutions and a lot of collaborative efforts. One of the things that we have proposed in terms of trying to see the problem in the Upper Basin in Arizona solved is if Navajo has unused apportionment in Utah or in New Mexico, that we be able to move the water into the Upper Basin in Arizona. The New Mexico settlement that we have does not permit this. We don't anticipate that the Utah settlement will allow this. I mean, what state really wants to sit down and negotiate with you a way of you not using your water within the state? But I'm saying, in terms of laying the groundwork for the future, I think those are the kinds of creative solutions that we're probably going to need to see ultimately if we're going to resolve the Upper Basin compact issues in Arizona. I call this a basketball term called no harm, no foul. In other words, if the water is used, if the water is not used in New Mexico or not used in Utah, but it is used in Arizona, as long as the water can be used by Navajo in Arizona, then in many respects it doesn't foul the states, it doesn't harm the states, and that shouldn't be a violation. The states, of course, can move water anywhere they want. The states can move water from the Upper Basin to places outside the Colorado River Basin. States can move water to accommodate their needs. What we're asking for is for Navajo to have those same rights. As a sovereign entity, Navajo ought to be able to move water within its boundaries. We're not talking about marketing water interstate. We're not talking about marketing water to Las Vegas. We're talking about using water within the boundaries of the Navajo Nation to meet Navajo municipal needs. So I think with that, let's take questions. Yes. Thank you.
We've heard several speakers today who have felt pretty strongly that the compact should not be reopened and that the solutions can be obtained by working below that system and solve them. What's your perspective from the Navajo Nation's point of view, the best way? Can you work within the framework of regulation, or do you think the statute needs to be relooked at, or the compact needs to be relooked at? Summarize the question.
Yes. The question was, from a Navajo perspective, the idea of amending the compacts, reopening the compacts, can we work within the framework? And I think that perhaps the last slide sort of answers that question. What I'm saying is we can work within the framework of the compacts and get these issues resolved, but they do require people to look at things just a little bit differently than they looked at. I gave a similar talk years ago to this where I was saying, you know, we got to be able to move water from state to state, and Scott Balcom from the Upper Basin Compact Commission in Colorado said, you can't do that, violates the compact. And it's like, again, you can look at the particular language in the compact, and Scott's right, and I can pull out, you know, my favorite pages of the Bible and say, you know, you're wrong. It requires everyone to come together and take a look at the big picture and see how we can resolve issues within the existing framework. So my job's hard enough without starting over with a clean slate in terms of, and I think most people will tell you, trying to renegotiate the compact in this day and age, it would be just too difficult. Yes, back there.
This would be an honest question, not a loaded question. In the context of your presentation, is Navajo water holding water?
In the context, I'm sorry. The question was, in the context of the presentation, is Navajo water Hopi water? No, I'm sorry. Is that what you're saying?
Yes.
No. Navajo water is not Hopi water. The Hopi Reservation has their own claims to its water rights. We're just simply talking about Navajo in this context. The Hopi tribes is located exclusively in the lower basin in Arizona. It has its own claims. We're really just talking about Navajo here. Yes?
I'm not an attorney, so this may be a
Good.
simple question, but
Yeah.
does any of this water rights law have any basis in common sense?
The question was, does any of this have any basis in common sense? And I assume that's a rhetorical question?
No, it's actually not. I mean, it's rhetorical, but it's also, I mean, at what level does this law become meaningless because it tries to say so many things?
I wouldn't say that the law is meaningless. I think that the one thing that's really, really important for water development in the West is some measure of certainty. So to the extent, and I know talking about certainty over a system of laws that we're constantly suing about is sort of an oxymoron, but I think that the laws make sense in terms of providing a mechanism for certainty to the extent that you can work, again, within the structure, within the framework, and resolve these questions. I think that the Colorado River law of the river is working. I think the states have shown a remarkable ability as among themselves to sit down and figure out how to make the compacts work for each of their issues as they come up. I mean, who would have thought years ago that we would have an Arizona water bank where you would actually where Arizona could bank water for the state of Nevada? I mean, the law of the river is not monolithic. It's changing, and it's changing in many respects. And what I'm saying here from Navajo is we want to be part of that change. We want to see the law of the river evolve in a way that that can accommodate the Navajo needs. And I think I've got a proposal here that is respectful of the existing structures, but it does apply common sense.
I guess my question was more, given that there's like so many competing uses for the river, how can you possibly have a concept that makes common sense? And I'm respecting the rights of Navajo in particular, but given all the other perspectives presented here, how can there be a common sense approach to this, given the fact that it's already so parsed out?
The question was, how can there be common sense with all the issues and the difficulties we have? And to me, I think that's really the question of the conference. The conference is talking about the Colorado River. How do we make sense of it? What are the answers to that? There is no stock answer I can give you on that. I think, hopefully what you'll take away from the conference is that there are a number of problems. They require innovation. They require collaboration. And I think we can do it. We're being preempted here. So if you have questions for me, feel free to contact me later.